I'm your host, Hillary Bricken, and this is the Cannabis Law Now podcast, where we regularly discuss issues related to the cannabis industry, including investment, day-to-day operational issues, and potential reform on the horizon that will impact all cannabis businesses and investors in the United States. Welcome, everybody, to today's podcast. It's going to be an exciting one because at this point in time, and today is May 17th as we're recording, we finally have in our midst the notice of proposed rulemaking from the Drug Enforcement Administration to make the historic shift from cannabis on the Controlled Substances Act from Schedule 1 to Schedule 3. And to discuss that move, which is admittedly epic, I have today John Hudak, who is a longtime friend and colleague of mine. He wears many hats, and as of today, he is the director of the Maine Office of Cannabis Policy. That's number one. But he is also a former Brookings Fellow, and that is really why I have him on today. Certainly, we can discuss what you're doing in Maine, John, but I brought you on because you were one of the first people in 2016 to deeply analyze what a reschedule would look like off of 01. And I think you even maybe referenced a Schedule 2 or 3 in the piece that you put together. And I also wanted your voice to be amplified and that you get the attention that you deserve on this topic because you are truly, I think, one of the few objective voices in the room on the topic because you don't have clients in the game that are pushing for a certain agenda. You're not in bed with the pharmaceutical industry and you're a regulator. So you have a grip on policy and kind of these real world implications of these major shifts in law. So welcome to the podcast, John.
Thanks for having me, Hillary.
And why don't you give us a little bit of your background? I know I just kind of parroted a little bit of it, but let's hear it straight from you so the people know you're legit.
Yeah, so like you said, I spent over a decade as a senior fellow at the Brookings Institution, where I worked on a variety of research areas, including immigration policy, campaigns and elections, federal spending policy. And then over time, cannabis became a really big part of my portfolio, both out of intellectual curiosity, but also, you know, if we rewind 10 years, 11 years, there just weren't a lot of think tanks talking about cannabis. You had the Heritage Foundation, which was pearl clutching, what about the children, the very Nancy Grace approach to drug policy. And then you had the Cato Institute, which was talking about it from a really libertarian economic perspective. But there weren't a lot of think tanks diving into the real nuts and bolts of cannabis policy. And so, you know, it's easy to be amplified when you're the only voice in the room. And I really enjoyed for a bit being the only voice in the room from a perch at a place like Brookings. And then about a year and a half ago, I hung up my think tank cleats and took over at Maine's Office of Cannabis Policy, where I still am today. I serve as the chief regulator and chief enforcement officer for the state's medical and adult use cannabis programs.
Well, I'm very happy for Maine. I think they're incredibly lucky to have you. And what I like about you most as a political scientist is that while you embrace the policy, you don't get lost in it. You've always had a very real world perspective regarding application and kind of real world implications for these moves with drugs, in particular for cannabis. And let's just dive right into it. This notice of proposed rulemaking is fresh. I don't even think it's 24 hours old as we record this. It's 92 pages. Some of the irony is that the actual proposed rule itself only takes up about 2 paragraphs on pages 91 and 92. And the remainder of the content really is the background and the support for why the rule is being brought to bear. And I want to dive into, number one, what do you think are the top, let's say 3 to 5 highlights of the notice of proposed rulemaking by the DEA. And I'm not going to launch into the context of how this all came to fruition. Obviously, this is highly political. We're in a presidential election year. But when you read the notice of proposed rulemaking, what really stuck out to you?
Yeah, so you're right. Like there's a very little bit of the actual sort of rule, and then there's the justification. And I think for a lot of your listeners, they're lawyers who are probably pretty familiar with regulatory law. But I think for a lot of your listeners, they're either lawyers who practice in other areas of law or they are not lawyers. And so the federal rulemaking process is probably pretty foreign to them. And this might be their first foray into just how damn boring it is. And the sort of long justifications for rule changes are pretty common. But I think in this space, it was a pretty fascinating deep dive from the Office of the Attorney General, from HHS, clearly reflecting, I would say a combination, and this is like my top line takeaway, is like a combination of science and an understanding of where society is at. And so if you strip everything away, and I'm not saying this is my position, there would have been plenty of justification within HHS and FDA specifically to keep cannabis at Schedule 1. They did it 8 years ago. They kept it at Schedule 1. Let's be honest, not a lot has changed in our understanding of cannabis in 8 years. But what has changed is the social approach, society's approach to cannabis. And so I think HHS felt a combination of that type of pressure, plus the fact that the president of the United States initiated the rescheduling petition, and he is their boss at the end of the day. And so you have this moment where typically does not happen in FDA, that is outside societal pressure, really ended up having an impact here. And part of the reason why I think it's important to note that there was this sort of outside pressure, some of it political, some of it societal, is a reflection of how much we previously misunderstood cannabis. Putting it in Schedule 1 made it this demon status, that it was so bad. If it was still believed to be so bad, HHS would not have acted in the way that it did in this case, in that it gave in to some of the political and societal pressure. But understanding that a lot of states have legalized for adult use, most states have legalized for medical use, and the sky hasn't. And that's an important context here. The second takeaway for me is how much DEA was dragged kicking and screaming to this outcome. I think for DEA, they understood the writing on the wall. They understood that their boss, the president of the United States, wanted this to happen. And they very vocally and passionately registered their objections in this analysis. And I think some people are going to read the notice of proposed rulemaking and have the approach of like, screw the DEA, like, what the hell are they doing? But in reality, like, that's good government to me. I would rather know that there is dissent. I would rather know that there is conflicting opinions within the administration. And despite those, this is the outcome we got to. Like, I can disagree with some of the things that DEA noted as objections. I'll also note that I think some of their objections are valid. Ultimately, I think we got to the right conclusion. The administration got to the right conclusion. We're in an environment where our politics is so prone to conspiracy theories and lack of trust. And I think having a document like this, which airs it all out, is how government should work. It's how I like my agency to work in Maine. And I think it helps build that trust to say, listen, this wasn't a bunch of yes men behind the curtain just saying, yes, Mr. Biden, yes, Mr. Biden, yes, Mr. Biden. There was this conversation internally that ultimately spilled out into the public. And whether you agree with HHS, whether you agree with DEA, whether you think cannabis should be descheduled, this is the type of government behavior that we should all embrace, that deliberative process that's so important.
See, that gives me a lot of comfort as an attorney in that in one of the few arenas government should be working and not biased one way or the other, especially when we talk about drugs and human safety and consumption. This type of kind of indirect dissent is a healthy exercise. Plus, you mentioned about how boring administrative rulemaking is, and my God, do I agree with you. In building the integrity of the administrative record, it is good to have debate because it will fend off frivolous challenges and it will force the science to work and probably even up the societal pressure around support. So I don't necessarily, I'm with you. I don't necessarily think it's a bad thing. I was surprised to see it. But then in reading the actual analysis where the DEA is pushing back on things, it seems that what they're really doing is setting the record straight that obviously it is the attorney general / president that is pushing for the rulemaking. They are doing their bidding administratively, but not that they reject it wholesale. They want more data and information.
Yeah, that's right. And what I'd say, Hillary, is that is a remarkable change in posture for DEA. I think a lot of people are going to read this and be like, oh, that's drug enforcement doing the drug enforcement thing. But, if you rewind even 8 years ago, DEA's position was like, yeah, it's Schedule 1. It should be Schedule 1. It's a no-brainer. This is bad, blah, blah, blah. I mean, that didn't pour out into the public, but that was the approach DEA held. And here, they're, like you said, they're not wholesale saying, like, no, cannabis is, an awful thing. They're just saying we don't have a lot of data yet, or we don't have enough data yet for them to be comfortable in the decision. Now, if we're talking about drug scheduling and the debate is between law enforcement and scientists, which if we boil it down, that's the debate between FDA and DEA, scientists versus law enforcement. I'm going to take my cues from scientists every day and twice on Sunday. I think they are still very valid perspectives and perches, and that information needs to get out there because let's be honest, I think a move to Schedule 3 is the right decision. I think the country is marching towards much broader drug policy reform, but the scheduling process has made mistakes before. I think cannabis being in Schedule 1 was a huge mistake in the first place, but we have had substances that move to a lower schedule and then information comes in and it's realized that it needs to be moved to higher control. And so putting that information out there for DEA, I think is part of the conversation to be like, hey, we might be making a mistake here. And if we are, here's a roadmap back to where we need to be. Now, just so your listeners know, I don't think we're going to be moving back to Schedule 2 or Schedule 1 for cannabis. I can't fathom a scenario in which that happens. But this is the type of conversation that exists in drug scheduling. For most people interested in cannabis, this is their first dipping their toe into that area of policy, the actual drug scheduling area of policy. But it's pretty complicated. It happens all the time. And there is a reason why the Controlled Substances Act asks both HHS and DOJ's enforcement areas, in this case DEA, to weigh in on it because it is a complex area of policy.
Certainly. I think it's going to blow the mind of many actors in the industry because they've never had to face this. On Schedule 1, ironically, their only temple at which to worship has been state law. So this is going to be either a rude awakening or welcome debate over a topic that just tends to generate a lot of passionate takes. And we can talk about some of that, but just to put the fine point on it, with the DEA wanting more essentially scientific data, right, as the top pharma cops here, this is all going to play out in the rulemaking process, right, with hearings and testimony, public comment from experts, I assume closed door meetings, public meetings, and it could take a while, right, before we even remotely get to a final rule.
Yeah, that's right. So the Administrative Procedure Act lays out a timeline in which, there's notice and comment period, but there are also periods that are a little more flexible in terms of the administration going through comment and responding to it. And let's be honest, most rulemaking associated with drug scheduling does not have a lot of notice and comment because most people don't give a damn about it. Pharmaceutical companies will, the American Medical Association and other similar bodies will weigh in, but you're not going to have Joe Smith from Central Maine weighing in on rulemaking around a blood pressure medication and its scheduling. But here, the Department of Justice is going to get probably hundreds of thousands of comments, which by law, under the Administrative Procedure Act, they need to go through and weigh. And some of it will be silly stuff, but some of it will be serious and thoughtful. And it is going to take DOJ time to go through all of this and ultimately put out a final rule. And even then, that sets off the Congressional Review Act, by which Congress can reconsider the rulemaking. It will surely set off litigation. And so I think this is an important step forward that the administration is taking. But whoever gets elected, I guess I should say whoever gets reelected, because someone's getting reelected in this November, whether it's Trump or Biden, this probably won't be settled in that term. It will probably be settled in the next president's term. And so it's not to say that the rule won't take effect, but I think thinking about what we consider settled law, major litigation ending, et cetera, we're years and years away from that.
Yeah, I think in kind of diligencing this entire process, because drug scheduling is its own animal within administrative law. one of these drugs that was moving around on the schedules, I think it took the DEA 14 years to basically settle it out. And that was a drug of, in my opinion, no consequence, like this one is now, given the democratic experiments that have been set up in the states. And we'll eventually talk about that. But let's get into what I saw as maybe a more major contention between DEA, HHS, FDA, and it's regarding Schedule 3 is the most appropriate schedule and how the HHS came to that conclusion. And I don't want to get too far into the weeds because it is out there, but typically there's a 5-factor test that's used. After we determine that something should be scheduled, then we determine the schedule it should go on. That 5-factor test basically determines the appropriate schedule. DEA in the notice of proposed rulemaking seems to be getting after HHS for only using a novel 2-factor test, basically to determine, which is really important, the currently accepted medical use of cannabis, which HHS FDA found that there were 7 indications for which it would be medically appropriate. The Office of Legal Counsel, which supplied an opinion to the Attorney General's office. And that's what they do. As you know, John, they give opinions, advisory opinions, and they basically advise the president and the executive agencies that the 5-part test that's normally used is quote unquote impermissibly narrow, and that the HHS 2-factor test was satisfactory. See, this to me is where the prohibitionists and the people that don't want this to happen can lock on legally, procedurally to say, you violated the law. This needs to come to a screeching halt. But how do you see that?
It was a really interesting approach that was taken. And so I think if you pull back, it's kind of interesting because the argument is a 5-factor test is too narrow. So let's go with a 2-factor test, which somehow seems narrower. When you start to dive into it, the narrowness construct is that the argument is the 5-factor test is too focused on the type of gold standard research that we are used to. That is double-blind placebo studies, that type of research. And so the argument is, listen, we have a lot of data and a lot of information from the states that have been dabbling in legalization for decades now, right? I mean, we're pushing 30 years of legalization for medical in California. We're better than a decade now for legalization for adult use. I mean, July 1st, right, is going to be the 10-year anniversary of commercial sales starting in Colorado. And so the narrowness of being too restrictive in the 5-factor test is really essentially arguing that cannabis is unique, and it is in so many ways. Cannabis policy is unique because when we're talking about drug scheduling generally, we don't have state markets that are operating, that are already providing the drug that is under consideration. And so I think OLC is smart. It's something I've been arguing for a while. I know, Hillary, it's something you've been arguing for a while, that we need to think about cannabis differently because it is different and the market is different and the information environment is different. And so moving toward a broader understanding and a broader perspective of what we see as accepted medical use, risk of abuse, etc., needs to take into account decades of information that we have at the state level. I agree with you 100%. I think this is going to be something that does become litigious, particularly among prohibitionists. I think one of the arguments is going to be a new rule, a new regulation, is that the regulation is arbitrary or capricious. And I think one of the arguments is going to be that this is an arbitrary approach. But I would flip that argument on its head and say that if OLC did not provide a sort of backdrop or a backup for the transition to the 2-factor analysis, that the 5-factor analysis actually becomes arbitrary because it ignores so much information that is out there. And so I think prohibitionists ultimately are going to have a lot of really lousy days in court when it comes to challenging Schedule 3 status. And I think what is, like you said, this has only been out for less than 24 hours as you and I are taping this. What I think jumps off the page to some people as lunacy is actually going to be the solid legal foundation for why this scheduling decision is ultimately upheld by courts of appeals.
So, and just to play a little devil's advocate, because it's worthwhile, and you're so articulate on this, and I love your takes. Do you think that going from the 5-factor to 2-factor, even if it's got some legal backing, is reflective of the social pressure you spoke about early on, that clearly, even if it's anecdotally, the states are bought in. There's clear medical effect here. We may not know the full extent because we haven't been allowed to research it, but that this is a product of that social pressure to treat this differently, in addition to maybe a new legal standard that's just as adequate.
Yeah, I think it would be foolish to suggest that it is not a signal of the social pressure and political pressure that exists. And I think that is, baked into this as you read along. And I think it's going to make prohibitionists want to tear their hair out. I'm not one who would argue that our drug safety protocols in the United States should entirely shift to this two-factor analysis. But when you have this bizarre scenario in which the federal government says something is illegal and states, not just illicit actors within states, but state governments like my own are authorizing the activity to produce, manufacture, and sell that substance that the federal government says is illegal, it creates a different policy environment. And yes, there's societal pressure there, but part of it too is just a reflection of the policy realities. And I think while there will be arguments that this came about because of social and political pressure, which can certainly factor into a court's understanding of whether the rulemaking process worked effectively and as it should under the Administrative Procedure Act, I think also courts are just as charged to think about the broader policy environment and all of the information that weighs into it. And I'm not a lawyer, I'm not a judge, but for me, if you think about, let's boil it down to like a criminal trial, right? If there is 99 pieces of evidence that point to someone being guilty, and you go in to a judge and you say, here's one piece of evidence that suggests that this person is guilty. A judge might say, like, that's not a lot. There might be other issues here. So why not bring all 99 pieces of evidence in and display it to a court? In a criminal trial, that's what a prosecutor is going to do. In a defense attorney in a criminal trial is going to bring all of the exculpatory evidence that they can bring to bear. So why not bring all of this information out? And I think when it eventually gets challenged in federal courts, courts are going to be pleased that all of the information that could be brought to bear was brought to bear in this conversation.
Well, and certainly public policy is always relevant. It may not be the most primary factor, at least in civil litigation, but it's always a consideration, right? Are courts acting in the best interest of the public based on the body of law and the real facts in front of them? Obviously, it's a very fluid situation, especially this one. Now, let's move on. And this will probably be the last thing I asked you about the notice of proposed rulemaking itself. People were banging the drum in both camps about international drug treaties. It's something that we can't skirt. It's a reality. They're complicated and they're antiquated. OLC, the Office of Legal Counsel opinion, essentially came to the conclusion that none of these treaties, none of them, actually require cannabis to be placed in Schedule 1 or 2. But then it seems that the DEA concludes that we can do this move. We have the authority to do it. The move itself will not violate the treaties. We can continue to honor our treaties so long as we ensure that Schedule 3 controls remain in place. If I'm getting that wrong, let me know. But I glommed onto that because then I look at the state experiments, and this will be the next thing we talk about and probably the thing that's on everybody's mind if they have a licensed cannabis business in one of these states and state regulators. Is that how you read that from the DEA about splitting the baby on compliance with drug treaties?
Yeah, that's how I read it. And I will say the caveat here is this is the same federal agency that for years said medical cannabis couldn't be allowed because of our treaty obligations, when in reality, the Single Convention and its successor treaties have specific carve-outs for the medical use of scheduled substances. And so I typically take with a grain of salt what the DEA says about our treaty obligations when it comes to controlled substances. But my reading of what they said here is your reading of it. And I actually think in this case, they're right. It is not a violation of our treaty obligations so long as there are controls, federal controls around production and distribution of that substance. Now, it does fly in the face of what state experiments are, which are absolutely, without a doubt, no questions asked, violations of our treaty obligations. But Canada and Uruguay have legalized, and now Germany has legalized adult use recreational cannabis, explicit violations of their treaty obligations, and nothing has happened to them in the international community. And so it is the obligation of DEA and the Office of Legal Counsel to bring up issues around our treaty obligations. But the United States typically doesn't let treaty obligations get in the way of a policy it wants to ultimately chase. And I don't think it's going to have an effect here. And I think being the first person to the party of breaking a treaty obligation is always a little uncomfortable. And what I always say is, Canada's a big, booming, G7 economy. And so it's easy to ignore them violating treaty obligations, but nothing happened to Uruguay. And if the international community didn't penalize Uruguay for it, and I say that as I love Uruguay, it's a beautiful country, nothing against that country, but Uruguay is not the United States. Uruguay is not Canada. And if Uruguay can get away with it, even if ultimately we are violating our treaty obligations, I don't think a lot of Americans and I don't think a lot of people in the Biden administration are going to lose a lot of sleep over that.
Understood. Fair take. And now let's talk about this apparent elephant in the room. And when you and I spoke about this last, we were on a panel together in Michigan, talking again to a bunch of lawyers in suits, speculating what a Schedule III world would look like. There is a lot of talk, some alarmist, some conspiratorial, some totally dismissive about what Schedule III means for these existing state legal markets like the one you're in Maine. And is this the DEA's second bite at the apple for enforcement? Because under Schedule I, even though they did nothing, they were basically bound by the Cole memo, which has now been vaporized, and U.S. attorneys simply wouldn't prosecute the cases. There was no interest, taxpayer dollars, support, or resources to pursue something like that. Why does this time, at least to me, it feels different? And it might feel different because we have these controlled Schedule III drugs in existence that, to your point, they didn't have existing over-the-counter state markets beforehand. So to me, it feels substantively, legally and enforcement-wise, like a paradoxical universe where how could you treat one Schedule III substance differently, carve it out, even if it's by omission, right? They just lay down, they never say anything about it. When you've got these others like testosterone, ketamine, etc., you've heard all of it, that you can only get through the doctor's office. Tell me why I should not be concerned about that.
Yeah, so it doesn't feel different to me. My take has been and will continue to be, it is what I've told the administration here in Maine. It's what I've told every licensee here in Maine who has asked me. This does not change our market in Maine. It doesn't change things for our operators in Maine, except potentially changing their tax obligations to the IRS. My take has been, if DEA wanted to do something about cannabis, they would have done it when it was in Schedule I, when it was deemed as a worse, quote unquote, worse drug, a more harmful drug, a scarier drug. Its movement to Schedule III doesn't change their enforcement authority at all. They have just as much authority against the programs that I administer in Maine and my colleagues do across the country. They have just as much enforcement authority for cannabis at Schedule I as they do it for cannabis at Schedule III. It is going to be damn near impossible at this point for the DEA to put the toothpaste back in the tube. They tried their damnedest in the mid to late 90s and early 2000s to do this in the early medical legalizing states, California, Colorado, places like that, and that didn't work. I don't see the political interest from the Biden administration. There certainly wasn't the political interest in the Trump administration actually to go out and start enforcing against state programs. I mean, the way I look at it is, with Jeff Sessions as Attorney General, lighting the Cole memo on fire, issuing what I would call the Sessions memo as a result, didn't result in national enforcement against state regulated programs. I don't think the move to Schedule III is going to do it. And also, you have a president who has spoken supportively of state programs. He has had an administration and an attorney general and U.S. attorneys across the country who have not enforced against these state programs, initiating a rescheduling petition that clearly politics factored into. Why on earth would he then, once rescheduling happens, go call the attorney general into the Oval Office and be like, okay, let's nuke him now? Like, I just don't see that scenario playing out. Like, I understand the concern that is out there. There's a lot of misinformation out there that, like, oh, now FDA has authority. FDA has always had authority over cannabis. They've sent letters out to businesses that have said you're making medical claims for cannabis that are inappropriate. This doesn't change the enforcement environment for DEA or FDA. I think we're still going to have a non-enforcement doctrine under President Biden. If President Trump is reelected in November, I think that will continue. I think the writing is on the wall about where the American public is cannabis policy. I think if you talk to the strongest prohibitionists in the country off the record and ask them, would you rather drug enforcement money be used against cannabis or against fentanyl? The answer is always fentanyl. And we don't even have the resources to deal with our fentanyl problem in the United States. Why divert even a penny of it towards something else that the vast majority of Americans see as not a harmful substance or not as harmful of a substance?
And so if there's not going to be this kind of conspiratorial mass shutdown, I've never envisioned that. Do you think the feds force DEA registration and all of the hoopla that comes with making Schedule III controlled substances? Or is that kind of in the same boat where we won't see a pan shutdown and we also won't see these state licensed companies impacted by healthcare laws and drug development rules, et cetera? And they really are kind of in their own realm here, legally and regulatorily speaking.
Yeah, I don't see the push for requiring DEA registration. Again, they could have required DEA registration under Schedule 1, right? And they didn't choose to do that. I was on a panel years back, and I think it was in Oakland, and someone on the panel, hell, it might have been you, Hillary, made sort of a brilliant point, which was, their vision for what cannabis policy would be in a rescheduled world is kind of like the difference between a chiropractor and a massage therapist. There are similar techniques that both of them use, but one of them is a physician and one of them is not. And they're treated very differently. They're regulated very differently. They're treated very differently by insurance companies for the most part. The idea that you can't have sort of peer behaviors or peer activities or peer medicines that are treated very differently just doesn't necessarily hold up. And I say that recognizing that we tend not to have those types of peer tracks for substances, but the chiropractor versus massage therapist thing made sense. And if there are any chiropractors listening, I'm sure they're going to be pissed that I'm comparing them to massage therapists. But ultimately, you can look at cannabis very similarly, right? You can go to a medical retail store here in Maine, a medical cannabis retail store here in Maine, and you can, with a card, you can get cannabis. And the person behind the counter is not supposed to say to you like, oh, this cures, MS, or they're not supposed to say that. I'm sure some of them do, but you're sort of just flying by the seat of your pants with it. You're like, I hope this works. I'll be honest. I'm not a medical cannabis patient here in Maine because the legislature won't allow us to test our medical cannabis for adulterants. So I don't use it here, but I have been a medical cannabis patient elsewhere. And it is very much a trial by error process. I don't have that same trial by error process typically if I go to CVS for a pharmaceutical. And so I think understanding cannabis to have two different tracks. We are going to have a pharmaceutical version of cannabis. We already do with Epidiolex and Marinol and things like that. And we might have more in the future that has been tested, and you can go in and have pretty good confidence that this is going to work for the thing it's prescribed for. Or you can go to the dispensary or the retail store and try until you find something that works. And not to belabor the point, but one of the interesting things that happened for me a few years back was I got asked to participate in a drug trial, a cannabis drug trial. I have what's called an essential tremor. So if you've ever been around me, you'll see I have a little bit of a hand tremor. It's benign. It's not like it's Parkinson's disease or something like that. It's benign, but it's noticeable. And there are cannabis formulations that can be used to treat it. I think it was like UCSD or UCLA was running a drug trial about it. I declined to participate. I use cannabis for a different medical condition. And typically when I use cannabis, it makes my hand tremor extraordinarily worse. I'm sure there's a formulation that can help treat it, but it sort of goes to show that like some people might use cannabis for their hand tremor. If I use cannabis for something different, it amplifies my hand tremor. And I think that's the sort of thing, like I've gotten a bad massage before, gotten a really lousy massage. I've gotten off the massage table and my back is killing me. That's some people's experience with cannabis. And I think we're going to have that sort of dual track process without DEA stepping in.
Well, you've heard it here, folks, that we might see bifurcation between, let's say, a choose your own adventure health and wellness industry, which does exist with botanicals, dietary supplements, you name it, right? Where buyer beware sounds strong, but you're kind of on your own with education and you have autonomy over your body. And then you've got the pharma grade, where you're seeing your treating physician for on-label indications, maybe even more potent. That world I can get behind, because that to me, my lawyer brain makes sense, other than some arbitrariness where we get state markets, but no guidance on how they're inevitably going to be treated. That's what I think what's making me uncomfortable. Now, last question before I let you go. And it's a tough one, but a fun one. Are we getting a rule in 60 days?
A rule in 60 days? No. I mean, the notice and comment period is going to close in 60 days, but like I do rulemaking here in Maine for, I've only been in the job for 14, 15 months now, and we've done a few rounds of rulemaking, and going through the notice and comment period in a state with 1.3 million people, mind you, going through after the notice and comment period through all of the comments, we are legally obligated to do that. And we make statements in response to the notice and comment period that are exactly that, responsive to the comments that we receive. And, you know, we'll get 30, 40, 50, 100 comments on a rule, and it takes our office a lot of time to go through all of that. Like I said, I expect hundreds of thousands of comments on this proposed rulemaking. And now, granted, you know, the Department of Justice has a hell of a lot more people than the Office of Cannabis Policy in Maine does to work on this stuff. That thoughtful process is not just important, but it is required under the Administrative Procedure Act. And a violation or a deviation from thoughtful responsiveness to those comments will create a legal situation in which the rule can be thrown out by the courts. And so, yeah, I don't think we're going to get a rule in 60 days. I think the president would like the rule to be out before the election, but in reality, for most Americans, the rule's already happened. This is already policy. The door's been closed. In fact, the announcement, the leak, and then the announcement a couple of weeks ago was the end of the conversation for most Americans. The president's going to get the political benefits, if any, that he's going to get out of it. Most Americans aren't going to see a change anyways around Schedule 3. The business owners might with some tax relief. But ultimately, now it's just the boring, tawdry parts of administrative law that get to be bearing out. And nerds like you and me, Hillary, and others are going to be hanging on every word and every release. But for most Americans, this conversation has ended.
All right, dear listener, you've heard it again here. Don't buy into the internet. We will not see a rule in 60 days. I had to ask that question to clear the air. Now we get to see how the sausage is made for probably months and years to come. So, John, thank you so much for your time and attention. It really has been very illuminating. I sincerely hope at some point you get to publish more literature on this, because we'd all benefit from that. Thanks again.
Thank you, Hillary. It's been a blast.
And that concludes today's episode of the Cannabis Law Now podcast. Until next time, stay alert, stay alive.